Okay, we're gonna get started. We've got a full room and I see lots of familiar names and lots of really interesting details about where people are from. We've got Istanbul in the room. Wow, thank you for joining us. We've got New York. Hello, Ari. We've got Boston. Hello, Woody. We've got Utah. So welcome, everyone. It's really great that we're able to meet together for this really exciting event for CLIC. So I'm gonna just jump in with an introduction and say, hello, my name is Tony. I am in Boston. I am the managing director at the Center for Law, Innovation, and Creativity, who is hosting this event. This event is called The New Digital Divide, and it's part of a three-part series, actually, that focuses on IP and tech. And our theme this year looks at the ways that tech companies and the lack of regulation seems to have created a new type of divide where for a long time, the argument has been that we need accessible or we need equitable access rather to technology. And now we're living in a time where technology is accessing us. So if we think about contact tracing, if we think about the triangulation of social media data, pinging our phones to, for geolocation features, we're entering this or have already entered this new and really interesting time about what it means to live in the digital world today. So that is the theme that informs and has shaped our theme or shaped our series for the for this academic year. And we are delighted to be joined by our first speaker, who is, I'm sorry, I'm a little distracted because a ton of notifications are going off and I try to turn them all off. So I'm gonna stop pretending like I don't hear them. I'm just like, shh, right now. So anyways, we're delighted to be joined by our first speaker. And I'm gonna turn it over to Professor Woody Hartzog, who is a faculty member at CLIC or at the Northeastern University School of Law, of which CLIC is where CLIC is housed, to introduce our speaker.
Thank you very much. It's a pleasure to see you all on here. It's a joy that even in these times we can still get together. My job is to introduce one of my dearest friends in the world, Ryan Calo. On paper, I'm going to put Ryan's bio in the chat because you can read a lot of the accolades that Ryan has. Ryan is the Lane Powell and D. Wayne Gittinger, did I pronounce that right, Ryan? Associate Professor at the University of Washington School of Law. That's his title. You can learn a lot from him. Ryan is an absolute leader in several fields, so much so that it's difficult to summarize. He wrote some pivotal privacy law scholarship on things like privacy harms, things on online manipulation, which many of us routinely cite with almost every article that we write. Ryan has led the way on robotics and artificial intelligence law and policy scholarship, writing some key articles on drones and bots and free speech. He is also working on a hotly anticipated book about law and the field of law and technology generally, which I highly commend to all of you to keep an eye out for when it comes out. Ryan's the co-director of the Multidisciplinary Tech Policy Lab and the co-founder of it as well. Someone that's done an incredible amount of work, and I highly commend you to look at that. He also is the co-founder for the WeRobot Conference with Michael Frumkin and our dearly departed friend Ian Kerr, which is the premier conference for law and robotics and artificial intelligence discussions in the United States. And if I may be so bold, Ryan, the world, and maybe or maybe not, but there's a lot of things that I could say about Ryan with respect to all of this, and suffice it to say, he is on the vanguard of these issues. I could also tell you about some of the personal relationships that Ryan has formed, not only with many senior scholars in the field, but the incredible job that he does working with junior scholars and being an incredible mentor and a guide for everyone in this area, someone that I'm eternally grateful to know and have in our community. I could tell you about the time that he and I skipped out on a major conference to go see the movie Her in New York City in the middle of a blizzard because it was probably relevant to artificial intelligence and the law and policy. Or the time that we stayed out so late at WeRobot that we missed the whole first part of the next conference. But I'm not going to tell you about those times. But I am going to tell you about one story that might embarrass Ryan just a little bit. And he doesn't, I don't even know if he knows this story. So at one WeRobot conference, we had adjourned for the evening and we were all sitting at a restaurant outside. And Ryan was sort of holding court with some of the junior scholars that were new to WeRobot. And as he always does, he was being insightful and witty and warm and welcoming, and everyone was having a good time. And then Ryan excused himself. I think he went to the bar to maybe grab another drink or something to eat. And I was in earshot of these two junior scholars. And they turned to each other and audibly said, "Can you believe we are talking to Ryan Calo?" And I don't know if I ever told him that or not, but it captured the kind of enthusiasm that Ryan brings and the importance of his scholarship. As someone that I consider to be a leading light in our field. And so can you all believe that we are getting to hear Ryan Calo? Welcome to Northeastern University virtually. Thank you very much, Ryan.
Wow, thank you. That has to be maybe the warmest introduction that that maybe I've had, and I really appreciate it very, very much, Woody. You know, I right back at you. I mean, you know, you've been an inspiration, and so a couple of quick things. So first of all, WeRobot, the conference that Woody mentioned, is actually happening virtually this week. And so there's going to be like a launch event, and then you're going to be able to see some of the pre-recorded but really lively and generative sessions at WeRobot this week. So keep an eye out for that. The folks at Ottawa are, yeah, thank you, Woody just put it in the chat. The other thing I would say is that, you know, speaking of Ian, who Woody mentioned, you know, Ian was really the model for at least for me, and I think for many people, in terms of how to engage with the community as a whole, junior and peer and the like. He was such a warm and intellectually generous and just engaging person, and so you know, those of us who were lucky to know him well benefited hugely from his mentoring and his example. That was quite a deep loss. Among others, by the way, Ari, another example of that would be Joel Reidenberg at Fordham. I mean, you know, it's been a time of great loss in recent years. So I am so excited to give a lecture today at Northeastern and at CLIC. And I got to say that, you know, Northeastern, in my view, is doing it right. And so, as Woody alluded to, I'm in the middle of researching a book about law and technology and sort of how do fields come to be formed, what are best practices, and the like. And in my view, Northeastern is doing the exact right thing. So first of all, you know, one of the things that I've learned over the last, you know, decade or so has been that there are very few interesting questions out there that are capable of resolution by reference to any one discipline. And so increasingly you need to hold hands across disciplines. Maybe you have dual training. Maybe you just talk to folks who are in other disciplines. You're looking at other disciplines, and they are also in turn looking to us as legal scholars. And I think it's important that we both recognize the importance of holding hands across disciplines, but also that we as legal scholars make ourselves and our work known and available to folks in other disciplines who, turns out, are quite excited about it when they realize it. And so one of the things that Northeastern does so well is to sort of try to merge those two things institutionally through cross appointment, through hiring people with dual training, through having programs like this one that are deeply interdisciplinary. The other thing I would say is that in the speaker series, I cannot recommend more that you would also tune in to Kate Darling and Joan Donovan, who are just two absolutely leading lights in their respective fields. One in the social aspects of robotics. She's also a huge IP scholar, but let's just focus on the probably what her talk will be about. And the other in the field of misinformation and disinformation. And I've gotten, I'm relatively new to this field. I've only been working in the field of disinformation and misinformation for maybe the past 6 months to a year, but I'm part of a new center at University of Washington. And I cannot tell you how important her work is to that set of inquiry about misinformation and disinformation and so on. So I highly recommend that. So you're going to hear about social robots. You're going to hear about misinformation and like what's and I'm going to talk to you about administrative law. I'm going to talk to you about administrative law. Now, for the law students out there, there is a rumor that is circulating in law schools that administrative law is boring. That is not true. That is not true. That is fake news. All right. I mean, administrative law is super exciting. It's really, really interesting. And so, that is not a hard pitch anymore because of the way in which administrative agencies are coming to the fore due to politics right now. Right. And so, for example, whether it's like the faithless Department of Justice, which is full of, incredible prosecutors, some of whom have been dear, dear friends of mine, just really amazing people. But in the leadership right now, it's just, it's just in front of us because it's just so faithless at the moment. To the manufactured incompetence of the U.S. Postal Service, which has been doing nothing but making money and connecting us, and it's now facing political pressure at a very difficult moment. To worries about political pressure at the FDA, at the Center for Disease Control. It's in our minds, right? So we're thinking about agencies and agency heads and politics, so it's in the fore. But I'm going to be talking about something a little different from the influence of politics on agencies. Although, as we'll see, hopefully at the end of my remarks, there is a political economy story here. It is about politics in the end. But I'm going to focus on algorithms, not necessarily on politics. Okay, and the talk I'm going to give draws from this work that I co-wrote with someone who I can't believe is actually taking time out of her day to watch me talk about our paper, but Danielle Citron, who is a magical force of nature and a leading person in multiple fields. And I hope that, Danielle, you'll feel like you should jump in because this is your work too. And so it's lovely to have you on here. But you can hear how I frame our paper to other people now from this. Yeah. So the question that I'm taking up today has to do with the use of algorithms by governments. Now, the use of algorithms by governments is also in the news. And it's in the news in a very specific way. So for example, I can't imagine that you've missed the protest by UK students in Wales and other parts of so students who have protested in Europe the use of algorithms to determine what their grades should be because the coronavirus is not making it possible to do the same kind of testing. And so they're using algorithms to anticipate what grades are going to be. And they've been resoundingly criticized on a number of levels, but also specifically because as Virginia Eubanks would anticipate, as many people would anticipate, they disadvantage people of lower socioeconomic status. So that was one of the complaints about them. And so you see these like literal bodies in the street, people on the ground on campus protesting the use of an algorithm by a quasi, by an institution in order to make decisions that are material to their lives. You see it in the United States, time and again. There's been a number of wonderful books written about it. Algorithms of Oppression, for example. The book I mentioned by Eubanks as well. Another book by The Weapons of Math Destruction. There's been a bunch of discussions about algorithms, but very notably, we saw maybe the first instance, or at least one of the first instances of an individual actually being indicted as a result of facial recognition not working well. So that was Robert Williams, who was falsely arrested and even indicted on the basis that or at a minimum arrested on the basis that a system appeared to match him as being at the scene of a crime, and of course it wasn't so. And so we see that, and it's highly visible. And so when you see headlines like these that talk about algorithms used by the government, algorithms used by institutions, they tend to look a particular way. And the headlines say things like, government relying on algorithms that are biased and flawed. Okay, governments relying on algorithms that are biased and flawed. And the public at a minimum, and many scholars additionally, focus on the latter half of that sentence, that the algorithms are biased and flawed, okay? And that is incredibly important work, incredibly important work. I mean, the fact that these things are biased and flawed is hugely important. It's important at the individual level because of the ways in which they're affecting real people's lives and lived experiences. It's important at a structural level because of the way in which algorithms and automation tend to reify and reinforce and amplify racial and gender and other biases within our society. So it's very, very important work. But the work that the emphasis of our paper, of Danielle and my paper, I think it's fair to say, is really on the former, right? Not that governments are turning to algorithms that are biased and flawed, right? But that they're turning to algorithms, And governments turn to algorithms for a wide variety of reasons, some of which are perfectly understandable, right? That is to say, the mode that they're addressing a perception of a real problem. Even the sentencing algorithms, which have been so deeply problematic, even the bail algorithm, the algorithms to determine whether you'll be detained prior to your defendant will be detained prior to their trial. Even those, have reasons behind them that we might think of as actually being in some small ways noble. Now, embracing algorithms instead may have been a terrible mistake and isn't maybe the wrong thing to do. But the base motivation had to do with the idea that the bail system, because it privileged people who were able to come up with the resources to get themselves out of jail prior to having their court appearance, systematically affected vulnerable populations, was racially discriminatory, was socioeconomically discriminatory, right? In the case of administrative agencies, these big, these big state and federal agencies, there also might be good reasons to turn towards automation, or at least a perception that there's good reasons to do that. But the point is that they're actually doing it. There was a recent study at Stanford that looked at the plans for the federal government, and particularly for agencies. In fact, it was in cooperation with an agency within the federal government that actually studies administrative law. That's how interesting administrative law is, that there's a whole agency within the government, and all they do all the time is study administrative law all the time. And so they worked together, and they found that a huge percentage of agencies were either federal agencies were either using machine learning or experimenting with or considering using machine learning within artificial intelligence. And so that we may see a sort of wholesale pivot towards that with mixed effects. But you know what Danielle and I know, and what many people on this in this meeting know, or in this lecture know, is that agencies have been using automation for a long time. Okay, well before machine learning or even algorithm, it was a household name, or a household word, right? They've been using it for a long time. Over the last few decades, agencies, particularly state agencies, have been turning more and more to automation to carry out their functions in society, whether they're making decisions about who should get certain benefits or getting them taken away. They're making decisions about who should gain admittance to something, how people should be evaluated in terms of the merit for their jobs, and so on and so on. Agencies are turning to automation and have been for decades and decades. So in many ways, you look at the Stanford study, and it's a story about how, like, hey, look, agencies are thinking about doing AI, and you know, maybe that's good, maybe that's bad, but it's happening. You're sort of reminded of, I don't know if I'll get this exactly right because I don't have it in front of me, but I'm reminded of a quote by one of my colleagues in computer science here at the University of Washington, Pedro Domingos, who in his book wrote that, you know, the problem with artificial intelligence is not that it's going to be too smart and take over. It's that it's too dumb and already has. Right. And so the basic idea here is that, you know, while we're watching to see how agencies are experimenting with this gee whiz bang new technology of artificial intelligence, you know, we got to keep our eye on the fact that they have long deployed software and automation, especially in the state context, but not exclusively. I mean, there's also the no-fly list, for example, which is a federal program where reliant on algorithms that affects people's liberty. But, you know, anyway, a lot is going on in the states. And, you know, automation is not always a bad thing, right? I mean, so for example, I referenced the, I referenced the Postal Service. Like if it's an automated mail sorter, right, that like helps people do their job, maybe we shouldn't dismantle it right before we do mail-in voting if it's working perfectly well and helping. I mean, automation is not intrinsically bad, but automation used to make decisions about people's lives is and can be problematic. So the legal literature, and I'm really talking about the legal literature here for now, but the discourse in law has long foregrounded the way in which automation by agencies interferes with process. The process that is due by virtue of the Constitution, by virtue of federal law, particularly the Administrative Procedure Act. You know, lawyers were obsessed with process at one level, and so what many people looked at or have been looking at is the way in which automation, when you substitute a system, a computer system or an algorithm for what a person used to do, that in a sort of classic law and technology way, that substitution then causes a breakdown of the requisite safeguards that we put in place for our values, okay? And so you see that in literature dating back decades, okay? So you see that, for example, when Danielle and I were researching our paper, we found examples, you know, from Paul Schwartz from the 1990s. And of course, Danielle herself has 2 papers in the same year, you know, now 10, 15 years ago. I think those papers are in 2008. Can I get a nod? Yeah, okay. So in 2008, writing about this phenomenon and technological due process, for example, which is just required reading in our field. Danielle describes the ways in which the shift to automation, the shift to algorithms has displaced safeguards for everything from, you know, rule making, like making new rules and having public participation. That has been sort of sublimated into software in a way that is hard to pick apart and hard to challenge, to individual decisions, to the constitutional guarantees you're supposed to get before material benefits are taken away from you, and so on. And she showed very elegantly all the ways in which our safeguards have fallen away or been eroded. And she came up with a number of very helpful ways to address this deficit, okay? And in addition to Danielle's work, I mean, Danielle's work in a sense has sort of spawned this cottage industry around thinking about process and automation, right? So you see wonderful work by Kate Crawford and Jason Schultz. You see, and you know, any number of papers I could point you to where there is a very thick, you know, creative, rigorous discussion of the way in which process has been interrupted by automation and can be restored. Okay, and that too is incredibly important. Now, in recent years, in sort of other disciplines, in addition to law, but in an interdisciplinary conversation on fairness, accountability, and transparency, we've also seen computer scientists, statisticians, people in the humanities, critical scholars, and others interrogating algorithms, but still focusing on that, you know, on that part of the headline, the flaws and the biases. And some people have been making really important moves saying, you know, it's not just about whether the algorithm works or doesn't work for this population or does. It's about who is being put under the lens of algorithms, who are they being brought to bear to affect, right? People are making these more systemic moves about, you know, who are we subjecting to algorithms and why, and sort of ideas. And isn't the deeper problem structural racism, or isn't the deeper problem structural sexism and the like? But there's this whole discourse now that's blossoming around unpacking notions of fairness and accountability and bias and the like, and sort of what to do about it. And it's a fascinating conversation, and there's an annual conference around that if you're interested. But again, in the legal discourse, you know, the way we've been interacting with that has again been around looking for, you know, we're lawyers, we're looking for laws, you know, we're looking for things like, I think of like Solon Barakas's and Andrew Selps's work on this disparate impact, for example, you know, or you know, work in the employment context about employment discrimination, which I can link to you. But the point is that, you know, we have been focusing on the law. So what Danielle and I are focusing on finally is not, again, process, but legitimacy. Okay, and this is your warning that this is where there's going to be a few minutes of administrative law. So if you need to shut your sound off for a minute, you know, that's really wise to record the meeting right when I'm about to talk about administrative law. I can see why you did that. You're like, wait, he's talking about administrative law? Well, I'm going to record this. This has got to be recorded. That's right. That's how awesome administrative law is. Okay, so you know, the whole idea of